Welcome to Justice at Work, Employee Rights and Protections in the Workplace.
Hello and welcome to Justice at Work, real talk from Filippatos PLLC. I am your host, Kevin Rosenquist, and I am here with Erica Healey-Kagan. She is one of the attorneys from Filippatos Law, where fighting for fairness in the workplace is more than a profession, it's a mission. Erica, welcome back. So good to see you again.
Thanks for having me. Well, I'm happy to be here.
Yeah, I really enjoyed our last conversation. I'm excited to talk further with you. Today, we're going to unpack federal layoffs, employee rights in today's climate. Obviously, this is a very topical conversation. So, how do layoffs for federal employees differ from those in the private sector? Because I think that might be something that people don't quite understand.
Yeah, and that's because the federal workforce and the private workforce, they're different in a number of different ways, right? When we think about working for the government, especially the federal government, it's oftentimes folks who start that job perhaps at a young age and they're in that job for a long time. It's known as a workforce with great job security. There does not tend to be great upheaval in the federal workforce because there are a lot of different protections in place that the government needs to go through to properly make dramatic changes to the federal workforce. So you don't see it happening very much for a number of different reasons, not the least being Congress and all of its strange machinations and its committees and votes and procedures. Congress actually is in control of how much money comes from the federal budget to fund the federal workforce. And the executive branch, the judicial branch, there's not really supposed to be unilateral changes made to the size of the federal workforce, and therefore there shouldn't be large cuts that are made, very quickly. But that is what we're seeing right now. And there's a couple reasons for that, but that's really one of the main differences is the federal workforce tends to be very steady because there are so many checks and balances in place to protect workers and, again, to allow the federal workforce, regardless of changes politically, having that consistency in the workforce is key because we don't want, every single employee of the federal government to potentially change every 4 years. That would cause the government to grind to a halt, right? So if we have job security and a steady workforce, that helps the government to run regardless of who's technically in charge, is the way to think about it. Private corporations, they'll decide whether to change their workforce every 4 years if they think that's good for business, or whether to shrink or expand based on perhaps the market force or how their business is doing, right? There's going to be a lot more fluctuations in any individual company in comparison to, a large federal workforce. Those are the major differences.
Sure. What is a reduction in force, or RIF, and what rights do federal employees have during that process?
Sure, yeah. So an RIF, sometimes we also call it a RIF, is basically a number of layoffs that are happening not for cause, meaning nobody in that layoff is being accused of not performing well. They're not being told that anything they did or didn't do is the reason for the layoff. It's usually caused by one of two factors, either financial downturn, such that the money's just not there to pay as many people as it once was, such that a company or a government needs to shrink the workforce, or there's a lack of work, right? So there's either like a lack of supply or a lack of demand, and there just can't be as many people anymore, right? So nobody necessarily did anything wrong, but for no fault of the employees, they need to be terminated. And so there are a number of rights in those circumstances. Again, different when we're looking at a government agency or government workforce to privately. But in the government workforce, especially because a RIF or a reduction in force doesn't mean that the employee did anything wrong, there are a couple of protections. One of them being that if possible, government employees are supposed to be offered reemployment elsewhere. So if one agency, for example, is shrinking, but another agency might be growing, depending on the cause for the RIF, employees from one agency should typically be offered reemployment elsewhere if there are availabilities.
Okay.
And the reduction in force is really supposed to be a last resort, right? People are not supposed to lose their jobs if it can be avoided, or if there's some way to mitigate the damage, again, offering them part-time employment or something like that, they're supposed to be offered that. And then another specific right to most government employees is that if there's going to be a reduction in force, there are very strict notice requirements. So what's not supposed to happen is all of a sudden you wake up one day and you've been terminated. What's supposed to happen is that you're supposed to be given at least 60, if not more days notice of this change in the size of the workforce at your agency or in your department. And again, at least 60 days, if not more notice before you lose your job. That's not always
So
happening.
you're not supposed to show up and have the doors locked and
Correct.
chained up and
Correct. And you're also not supposed to be, taken into a room and, with HR or whoever it is and told, unfortunately, your job's being eliminated effective today. That certainly can happen in the private industry, but in government, that's not supposed to happen.
Mm-hmm. Not supposed to. Can a federal employee just straight up challenge a layoff or termination?
So the short answer there is yes. The longer answer is it depends, because it depends what the problem with the layoff is, right? So as I said, if you haven't been given sufficient notice, there might be a way to challenge it. Might not get you your job back, but it might get you a few more months of employment potentially, right? If you haven't been offered a reassignment, you can try to look into whether or not that's available. Those are, kind of those two discrete examples. But then there's larger problems, like if you feel your inclusion in the reduction in force is actually being fueled by discrimination or retaliation. So for example, if you felt you were being mistreated and you had made a number of complaints to your supervisor, and all of a sudden then you get included in a layoff and you feel this was actually motivated by bias or discrimination against me, there are challenges that you can make. So again, the short answer is yes. The long answer is it's complicated. So in any circumstance, when you're being terminated, we always recommend that you seek the advice of counsel. And again, that attorney can let you know what your rights are and what rights may have been violated. It's definitely a situation that's more complicated than I'd like a client to be dealing with on their own. So, know that you do have options, and you should speak to an attorney to figure out what your best next step will be.
When it comes to, I know there's obviously protections for whistleblowers. Are there protections for whistleblowers facing layoffs or restructuring within federal agencies?
So that's an interesting scenario. As I said, whenever you have a layoff, the employer is taking the position that, your job was chosen for no specific reason, for no, we weren't motivated by any sort of improper, motivation or inclination. However, if you know that you have served as a whistleblower and you know that it was, let's say, a few months before or some short period of time before you got notice of your layoff, you justifiably have concerns, I'm sure, that the fact that you blew the whistle and then soon thereafter were terminated, those probably feel like they're connected. So that's another circumstance where we would encourage folks, again, if they've blown the whistle, which means that they have raised any sort of concern regarding a violation of the law or a violation of any policy within their agency, if they felt like something wasn't happening as it should and they told someone, just about anyone, it doesn't have to be that you told your supervisor or that you went all the way up the chain of command, but if you raised a concern about either illegal or improper activity and then you were included in a layoff, you definitely need to speak with an attorney, right? Because again, it is complicated, and your employer will say that that was not the reason that you were included in the RIF. And this actually applies for folks in the private sector as well as government, right? If you have blown the whistle and you are terminated for any reason, you should speak with an attorney, because just because your employer is saying that wasn't the reason does not mean that you don't necessarily have a claim. And really, you want an attorney to come in and review the series of facts and look at the evidence to see whether or not you have a basis to, bring a claim or make some sort of challenge with an agency. There's usually a lot of different options depending on what exactly happened, where you work, and what the time frame is.
When it comes to unions, do they kind of help defend federal workers during these layoffs?
So that's another great question right now, because it's something that unfortunately is changing at all times.
Right.
And
Yeah.
so, especially with this topic, although really with employment law and policies in general, sometimes things are rapidly changing. So I'm going to tell you the situation as we sit here right now.
As we sit here today.
Right?
Yeah.
By the time our viewers listen to this, things may have changed.
It
However,
could change by the time we're done talking about it.
That's right. That's right. I will look at my phone and see if I get a news alert about the very case I'm going to tell you about. So basically, federal workers, many federal workers are represented by unions. And what unions typically do is it's the power of the people, right? They negotiate on behalf of groups of individuals. It's called collective bargaining. So rather than, you and I negotiating about the terms of my employment, my union represents for me and hundreds of thousands of my colleagues. And in that sense, they have, the workers have more bargaining power, they have more leverage, and they can try to work out a fair deal that would be very difficult for an individual to negotiate on their own. Again, many federal workers are represented by unions. However, in a number of different agencies, the current administration has rescinded the union's ability, a number of unions' ability to collectively bargain on behalf of the employees. They've used a number of different justifications, one of them being national security, agencies like the Department of Defense, Homeland Security, some other agencies like that. Again, there have been a number of arguments that are being made in court. I believe it's on appeal right now, right? So we don't know exactly what will happen, but a federal court has ruled in favor of the government at this point in saying that, yes, there are federal workers who used to be represented by unions who the federal government is no longer obligated to bargain with. So we have people who, let's say a few months ago, were represented by their unions, and they no longer really have that representation in an effective way. That could change in the future. So
Yeah.
Again, the short answer is there are union bargaining rights that exist, but they're ever changing. And, it's another thing where, if you do have a connection with the union, you should be in touch with them about whether you've been impacted by this change or whether there are potential changes to come. And that's also something that federal employees can contact attorneys about, especially because things are changing at a pretty rapid rate right now.
Right. Yeah. If someone wants to appeal a layoff decision, is there a timeline they have to do so? And how does that process work?
Yeah, so there's a pretty strict timeline for a lot of different challenges that a federal employee can make. So I'm just going to give one example, which is if a federal employee feels that they've been discriminated against and they want to file any sort of lawsuit or any sort of claim, if they haven't notified their agency's EEO department, so their internal agency's Equal Employment Opportunity Department, within 45 days of when the incident happened, they may lose their right to litigate altogether. And
Oh, wow.
so, again, there are lots of protections for the federal workforce, but then on the flip side, sometimes there are much tighter turnarounds, right, in terms of timing that are imposed on the federal agencies than on private agencies. So that 45 days, if you're a private employee, you get usually at least 180 days to make a complaint of some sort. So if you're a federal employee, you should seek assistance again from an attorney as soon as you feel like there's a problem, because you might have very tight deadlines. Again, sometimes as short as 30 or 45 days to take that first step so that you don't lose your right to proceed the rest of the way.
Okay. I asked you this question when we were talking about LGBTQIA plus rights. What do you think? Where do you see the be my oracle here? What
I'll look
do
into
you
my
see
crystal ball.
happening?
Yeah, go ahead.
I'll look at your crystal ball. What do you think's coming down the pike? What do you think is are there are policy changes or recent cases? Are there anything that you think is going to move the needle one way or another in the immediate future?
Yeah. So I will take your, alluding to our LGBTQ chat, and I will do the same thing because it feels pretty similar right now that there's going
Yeah.
to be two steps forward, one step back, right? So one example of that is, I think as we all know, or anyone who reads the news knows, lots of federal employees have been given notice of fairly immediate layoffs, right? Hundreds of thousands of employees at all different agencies have been told your employment is terminated. But there have been a number of lawsuits, and some of them have been successful and some of them haven't. One successful one thus far was that I believe there was at least 100,000, if not more, probationary employees, which means it was someone usually within the first 90 days or so of their employment. Those probationary employees were included in a lot of these layoffs. And arguments were made in court that that is improper because you can only be terminated during your probation period for certain reasons, and that, right, the reasons in this case didn't apply. And the court agreed. So, again, hundreds of thousands of probationary employees were terminated one day, but put back to work, a couple weeks, couple months later. So that's one area where we saw pretty dramatic shifts one way and the other. I think that's going to keep happening, unfortunately, because as we've seen, the current administration is pretty set on reducing the size of the federal workforce. So I think they're going to, keep making attempts to do that in different ways. Our advice, again, is if you receive one of those termination notices, meet with an attorney because you may have options. It may also behoove you to potentially join up with other employees who are in the same situation as you to potentially have a collective lawsuit or to be part of a class action of some sort, right? There's a lot of different options. And I think for the next, who knows how long, we're going to see, right, actions being taken, being challenged in court, and we'll see. Again, some of them may be undone, some of them may not. We're gonna find out as we go along, but I think we'll see some 2 steps forward, 1 or more steps back, and we'll see where it goes from there.
If nothing else, the current administration is making you very busy, I assume.
Well, attorneys, yes. Attorneys sometimes are busy, but not for the reasons that we want to be busy.
Right.
That's fair. But yes, we're of course here for folks to reach out, whether they're terminated from federal employment, private employment. I think there's a lot of moving needles that are moving in all different sorts of directions. And so, especially right now, when we're seeing, crackdowns on DEI and, different companies taking different approaches to the workforce, it's an important time to, be vigilant of your rights and to seek counsel if something feels off, is the best way to put it.
Yeah, I like that. Seek counsel if something feels off. Just know your rights and make sure you're protected.
Exactly.
Yeah. All right. Well, great advice as always. Thanks for listening to Justice at Work, powered by Filippatos PLLC. If you're dealing with workplace discrimination, harassment, or retaliation, or you just want to know your rights, visit filippatos.law.com to schedule a consultation. And please don't forget to follow us, subscribe to us. We've got a lot more stuff coming your way. Erica, as always, so good to talk to you. Thanks so much for your time.
Thanks for having me. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.